Good morning. Thanks for joining us here on CBS News 24/7. I'm Lindsay Reiser, and we want to give you a live look right now at the Supreme Court. The justices just made a historic ruling in the case of Donald Trump v. the United States, saying, quote, under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. The decision goes on to say there is no immunity for unofficial acts. We have team coverage of this decision, from what it means for the former president's charges stemming from the January 6th insurrection to the political impact. Lawyers Scott Fredericksen and Jessica Levinson are standing by for analysis. We are going to begin with CBS News campaign reporter and attorney Katrina Kaufman. So, Katrina, really what comes down to it to me is the difference between official and unofficial acts. How does the decision lay out the difference between the two?
So the opinion makes determinations about certain of Trump's acts, but really what they're doing is sending this back to Judge Tanya Chutkan to make determinations about what can remain in this indictment by special counsel Jack Smith. What was Trump acting as an office holder versus acting as an office seeker? And this creates a really, really significant precedent for our country, that a president will be immune for what is determined to be his official acts. He will have absolute immunity for his core powers, and then for any other official acts, there's presumptive immunity. So it will be the government's job to prove that those acts can be qualified as unofficial. There's also separately a really important footnote that I saw in this opinion, which affirms the Department of Justice's OLC position that a sitting president cannot be prosecuted. And this is something that has been a precedent from the past, but has never been officially affirmed by the Supreme Court. This actually raises the stakes of this election for Trump, because it means if he's elected in November and takes power, none of these criminal prosecutions can proceed against him once he is president.
And so, Katrina, just to remind everybody how we got here, I just want to remind people some of the key important dates here. Remember, I believe it was August 1st of 2023 that these charges by Jack Smith's team were officially filed. We know some other key dates. For example, October 5th, this was the first time that Trump filed the motion to dismiss on immunity grounds. And then there were some filings in December. Jack Smith's team asking to sort of circumnavigate the Court of Appeals, the Supreme Court denying that, and then ultimately the Supreme Court agreeing to take up the case this session. So while it seems like the timeline for a trial before the election could be in jeopardy, help us understand the speed with which this has been adjudicated, the fact that the Supreme Court did actually agree to take this up this session.
So the timeline you're laying out is really important. And as you mentioned, Jack Smith had first asked the Supreme Court to take this up back in December, that is 6 months ago. They said that it wasn't ready for them to make a decision on. They had the D.C. Circuit make a decision. The D.C. Circuit found that there was no immunity for the president. Then the Supreme Court decided to take up this case, heard arguments in April, and we now have a decision. And of course, this is them moving quickly compared to a normal timeline. But given the expediency which they've handled other presidential issues, such as when Trump was potentially going to be taken off the ballot in Colorado, they determined that within 2 months. Or with U.S. v. Nixon, they determined that within 54 days. So they've now put this case in complete jeopardy. It's very, very, very unlikely that it will take place before the November election, given the vast amount of work that Judge Chutkan has to do. The best possibility for Jack Smith at this point, with laying out these charges in any form before the public before November, is to potentially have a sort of mini trial where they make determinations on what can remain in this indictment. And it's possible that could include witnesses and evidence, potentially even Trump himself testifying. So I think that that is the closest that we might get to an airing out of any portion of this indictment before November. But another important thing that the court has done here is that they've also taken away Smith's ability to use official acts as evidence. And so that is really going to slim down his charges against Trump.
So then, would that mean that we would likely see a slimmed down indictment before we see some of these evidentiary hearings in Chutkan's courtroom?
That's a good question. It's possible that Jack Smith has been working on a slimmer version of this indictment, but I think it really is going to be sent back to Judge Chutkan to make determinations. During the Supreme Court arguments, Trump's own attorney, John Sauer, had admitted that certain conduct from the indictment does qualify as private. So I'm sure that Jack Smith is doing everything he can to figure out a way to streamline this, but I think it's still extremely unlikely that this case can move forward before the election takes place.
And these oral arguments were in April, so I'm throwing you a curveball here. Do you recall which specific acts they were talking about when Trump's attorney conceded that some of those acts included in the indictment were private acts?
I know there were about 4 concessions, and some of them related to Trump's interactions with private attorneys, such as with Giuliani. They were related to the fake electors scheme. So all of these, I think, will fall into the private acts category. But the Supreme Court is really making it, with the way they've written this ruling, so that Judge Chutkan is going to have to make decisions on this and how the case can move forward.
And one more time before we let you go, I just want to go down memory lane a little bit. In the D.C. Court of Appeals, or the D.C. Circuit, unequivocally saying that former President Trump has no immunity. The Supreme Court could have left it there, but they decided to take up this case and they decided to rule. Can you elaborate a little bit on what the appeals court says? I believe it was a 3-judge panel.
Yes, the appeals court said that Trump had no immunity from criminal prosecution. They said that when he left the presidency, he was no longer President Trump. He became Citizen Trump, and thus criminal charges could proceed against him. That the president is not, a monarch. When the framers wrote the Constitution, they did not give the president immunity. That was a very conscious decision. And during the Supreme Court arguments on this issue, actually, Justice Jackson expressed the concern that the president could become the seat of criminality in this country if the president is allowed to be immune from criminal prosecution. Justice Kagan also brought up a really interesting hypothetical, because Trump's team was arguing that the only way a president could be criminally prosecuted for official acts is if they're first impeached and convicted. And Justice Kagan had said, what if on January 20th, the president orders the military to hold a coup? Then once he leaves office, it's too late to impeach and convict him. Would he not ever be held liable for that type of action? So, as many of the justices wrote in their dissent, this is setting a very dangerous precedent.
Katrina Kaufman, thank you so much for your live report outside the Supreme Court. Let's go ahead and now turn to our legal panel. Scott Fredericksen is a defense attorney and former federal prosecutor, and Jessica Levinson is a CBS News legal contributor and professor at Loyola Law School. Before we go to you, Scott, to talk a little bit more about the dissent, Jessica, I know you've been listening to my conversation with Katrina. Do you have any thoughts so far?
Yeah. So I think what the Supreme Court did today is answer a question of first impression. And we did not have an answer for when former presidents or current presidents have immunity from criminal prosecution. We had an answer when it comes to civil suits. What the Supreme Court said decades ago is that if a president is sued for monetary damages, again, a civil suit, that president enjoys absolute immunity if we're talking about official acts. So I do want to caution everybody that there's been precedent for decades saying that presidents are different, in part because we fear that they could be subject to frivolous lawsuits, frivolous criminal complaints, that we understand that under the Constitution, as the head of one of the branches, the presidents, frankly, are just different. And I know it's appealing to say that this undermines the idea that no person is above the law, but there's a lot of ways that we do treat presidents as different. For instance, you and I don't get to appoint ambassadors, appoint judges. We don't get to sign legislation. There's just different things, different duties that presidents have. And so while the court today is saying that presidents do have immunity from presumptive immunity for most official acts and no immunity for unofficial acts, I think that roadmap has been there for, frankly, decades. The other thing I would say is that Jack Smith, is this the timeline that he wanted? No, in some circumstances, but in December, he said, I want a decision by the end of the term. He got a decision by the end of the term. He wanted to jump in line. He didn't want the DC Court of Appeals for completely understandable reasons. He didn't want them to rule on this first, but they did. He then didn't want the Supreme Court, to take the case, but they did. This is the type of case that the Supreme Court takes. It's a case where it's going to be in constitutional law books. I'm going to teach this case. I'm going to teach it right after I teach the cases about immunity from subpoenas and immunity from civil suits. And this is going to fit as the end of that particular chapter. So I would say, is it a good day for the former president? Yes. Did they adopt all of the arguments that he wanted? No, they did not. I do not see that in this opinion.
Stand by. I got about a million more questions for you. But Scott, first of all, let's talk about Justice Sonia Sotomayor's scathing, blistering dissent, in which part of it that I want to pull up, she talked about presidential powers. When he uses his official powers in any way under the majority's reasoning, he will now be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune, 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 immune. What do you take that to mean?
Well, I think we have to remember that this scathing dissent was joined in by Justice Kagan and Justice Jackson, and their concerns are real. Let me back up and describe why, and throw out for you kind of a nightmare scenario, which I think the Supreme Court has provided, unfortunately, and unintentionally. Here, the court didn't just split the baby down the middle on this. It outlined a very robust, strong immunity for president. In the outermost official acts of a president, according to the Supreme Court, the president is immune. And if challenged, it's up to the prosecution to rebut that presumption. And in a prosecution, the government cannot use the private records of the president or testimony of its advisor. So let me put out one unfortunate, I think, scenario. Our colleague here, our professor from Loyola, has indicated we'll be teaching this, and I think this is a concern of the dissent. So while it's been rejected that the president can't just go out and shoot someone and be immune, I think the dissent is saying, here, what the president is able to do under this opinion now is this. Let's say instead now the president said, it has come to my attention through my advisors and the official agencies that a foreign power has infiltrated our election system, and it is all fraudulent, and has infiltrated the halls of Congress, and they are going to take control. I therefore, under my core constitutional and statutory duties, remember, absolutely immune for that, I am ordering the Defense Department to suspend elections and to take over Congress. I do that as part of my core statutory and constitutional duties. Now, according to this opinion of Justice Roberts, that the president enjoys immunity for. And that's what Justice Sotomayor is getting at. And that's why she's joined by Justice Kagan and Justice Jackson. It's a real concern because the Supreme Court in this opinion has outlined a very robust strength of executive power, very difficult to challenge. So in the future, if a president wants to undertake some, let's say, alleged criminal action, they'll make sure to cloak it under their core constitutional and judicial powers. So I think that's one of the takeaways I take from Justice Sotomayor's scathing opinion. And it's a legitimate question here. How does a prosecutor for a president that tries to take over the government, try an attempted coup, how do you prosecute that under this standard? Now, I do think when we get back to Justice Chutkan in a week, I think you'll see the special prosecutor, Jack Smith, come in, and he's going to tell the court, I've jettisoned any of the allegations and counts in the complaint that have to do with official action. The only charges we're going with now are the reduced charges that only relate to private conduct. And with that, Justice Chutkan is going to conduct hearings. And as your colleague indicated, there's going to be a mini trial. There's going to be testimony. But you're not going to hear evidence from the president's private records or from his advisors. Because remember, the Supreme Court said, can't use that now, cannot use that. And even if Judge Chutkan then says, look, I've decided these very limited remaining allegations are purely private conduct, and I'm ready to go to trial. Well, the first thing that the former president's lawyers are going to do is seek appeal at the D.C. Circuit and then to the Supreme Court, and that's going to delay it as well. So chances of this going to trial, very, very minimal.
And before, Scott, I ask you about how this will impact the other cases, not only facing the former president, but also defendants in Arizona and Georgia. Jessica, I want to ask you about a hypothetical. What does this mean for a hypothetical situation that Trump himself alluded to in the debate in saying that some of current President Biden's conduct, action or inaction at the border is criminal? What does this decision say about a hypothetical like that? If President Biden were to lose the November election and former President Trump were to regain the White House, if he decided that he wanted to go after President Biden?
I think this is such an important question because understandably, we're spending so much time talking about the former President Trump, and the criminal indictment facing him. And that is really important. There's no question about it. But your question goes to something that we heard during oral arguments from the justices, which is we're not just ruling on this particular case. This is a case about every other president and future former president. And to your question about, well, what if Biden was then at some point, he's going to be a former president. And then could the Department of Justice be used and arguably weaponized against him or used to file criminal charges? And I think the answer has to be, well, here's our guidepost, right? That there is absolute immunity for those things that only the president can do, those core functions. There is presumptive immunity for official acts. So if this falls within an official act, then here we go. We have presumptive immunity, and you would have to overcome that presumption. And so in that way, you could see this as protective. Again, I know it's so hard to separate the words Trump and Biden, but if we just say President X and President Y, then you can see that this is protective of whoever is in the Oval Office or becomes a former president. And that, I think, is it's an important question because it highlights the importance not just of this case, but every other case, and why I think you see such a lengthy opinion here, because they know that they're writing about more than just one president.
We'll have to ask about the other cases in a little bit. Scott Fredericksen, Jessica Levinson, and Katrina Kaufman, thank you. Scott and Jessica, you're going to be joining me again in our next hour. I want to go ahead and bring in CBS News Chief White House correspondent Nancy Cordis. So, Nancy, you've obviously been listening to our conversation. And the Biden campaign, I believe they released a statement, right? What are they saying?
Right. So they haven't yet released a statement on the content of the ruling itself and how they feel about this immunity distinction that the court is drawing. But they have released a statement that tries to refocus everyone on why this case has gone to the Supreme Court in the first place. And that's that according to a senior Biden campaign advisor, let's be clear about what happened on January 6th. Donald Trump snapped after he lost the 2020 election, and he had encouraged a mob to overthrow the results of a free and fair election. Since January 6th, this aide goes on to say, Trump has only grown more unhinged. He's promising to be a dictator on day one. He's calling for the Constitution to be terminated so that he can regain power, and on and on. So obviously what they're trying to do is to say, hey, look, yes, you're hearing a lot of legal arguments back and forth. The reality is that this all stems from Donald Trump trying to prevent the peaceful transfer of power to Joe Biden because he was angry that he lost. And they've even got a new ad out today that, in the president's own words, he hits Donald Trump on what he said about January 6th at the debate on Thursday night. Obviously, the Biden campaign here trying to refocus away from the challenges that Biden himself had at that debate and remind Americans of some of the false claims that the former president made on debate night about January 6th, about immigration, about the economy, and on and on.
And this kind of brings up an important point that Anne Marie and Jan were talking about prior to us going on the air about 20 minutes ago, and that is that if Trump loses, there's nothing to say that a trial couldn't begin once Biden stays in the White House. I mean, I guess if Trump were to be the one that were elected, that would throw the wrench in terms of a trial.
Sure. And I think, obviously what the Biden campaign would have loved would have been for this trial to go forward before Election Day, not only because it would keep Trump's legal problems front and center, but also because they argue that this case is central to democracy. The fact that a sitting president would try to overthrow a free and fair election, that he would encourage people to storm the Capitol. They think that that the outcome of that trial would have been something important for voters to know about before they cast their ballots in November. That's obviously not going to happen. I don't think even before today's ruling, most officials in the Biden campaign or here at the White House thought would happen. They knew the chances were very slim, but I anticipate that when we do get a statement from the Biden campaign, they're likely to argue, as we've been hearing so many Democratic lawmakers argue already this morning, that it fundamentally changes the definition of the presidency. It changes the relationship between the president and the people that he serves or she serves. And they are going to argue that this is yet another case of the Supreme Court putting its thumb on the scale for former President Trump. And finally, I think they'll make the case that this is why it's so important for their supporters to stick with President Trump, despite some of the challenges that he may have had last week in the debate, because one of the things that a president gets to do is name new justices to the Supreme Court if anyone retires, and that's obviously a possibility over the next 4 years.
Nancy Cordis, thank you so much for your time. We have more coverage of this historic ruling after the break. Stay with us. You're streaming CBS News 24/7.